Buenos días, mi nombre es Alejandro Chehtman y soy director de la carrera de Abogacía en la Universidad Torcuato Di Tella. Es un gusto darles la bienvenida a esta primera conversación Ditelliana de 2021. I'm going to switch to English now to welcome our extraordinary guest. It is a real honor to welcome Prosecutor Fatou Bensouda, prosecutor of the International Criminal Court, a symbol of the fight for justice for victims and one of the most prominent legal minds in the world. Before coming to the ICC, Prosecutor Bensouda occupied many of the most important legal positions in the Republic of the Gambia, including Deputy Director of Public Prosecutions, Solicitor General, and Legal Secretary of the Republic. She also worked at the International Criminal Tribunal for Rwanda as legal advisor and trial attorney before rising to the position of head of the Legal Advisory Unit. She was elected prosecutor of the International Court in 2011 by the Assembly of the States Parties, a position for which she was supported by the African Union as the sole African candidate. Prosecutor Bensouda has received many of the most outstanding awards in the discipline, including the 2009 International Court of Justice International Jurists Award, the 2011 World Peace Through Law Award, and the American Society for International Law's Honorary Membership Award in 2014. She has been listed by Time magazine as one of the 100 most influential people in the world, and by Foreign Policy as one of the leading global thinkers in 2013. As prosecutor of the International Criminal Court, she revolutionized the office, enhancing its capacity and significantly expanding its reach. As a result of that, she and senior members of her office were sanctioned by the Trump administration in 2020 over her investigation of whether American forces committed war crimes in Afghanistan. These sanctions were happily lifted last Friday by the Biden administration. Today, she will speak about the importance of having an international criminal court and how to support it. She will speak for about 25 minutes, and then we will have time for question and answers. So please send us your questions, even during the presentation, via the chat function that you have available. Welcome to Ditella and to Argentina, Prosecutor Bensouda, if only virtually for now. We're humbled and thrilled to have you.
Thank you very much. Thank you, dear faculty members, staff, and students from the Torquato Di Tella University, colleagues from the legal profession, distinguished guests. It is indeed an honor for me to deliver this keynote speech for the prestigious Universidad Torquato Di Tella in Buenos Aires, and thus contribute to your series of international talks project. At the outset, I extend my gratitude to Dr. Alejandro Chehtman, Professor of Law and Head of the Law degree, for inviting me to present this lecture. I'm really honored for the opportunity. In April, just 2 years ago, I had the pleasure to be in Buenos Aires. Having had the chance of discovering your beautiful and vibrant city on that occasion, I would have rejoiced the prospect of a second visit to once again enjoy your country's hospitality and culture, and to be with you in person for equally rich exchanges. Alas, it must be on another occasion in a future capacity as the COVID-19 pandemic continues to present obstacles, and I am concluding my mandate as prosecutor this summer. It is a privilege, nevertheless, to share with you today, through this virtual setting, a few thoughts on the importance of accountability and the rule of law, the role of the ICC within this context and its current state of play, along with reflections on my office's achievements, but also the challenges encountered during my term in the office, as well as how its role can be further strengthened and supported. The International Criminal Justice Project, and indeed the International Criminal Court at its heart, were built on the hard lessons of history of unspeakable atrocities and human suffering that for centuries have reigned with impunity. As Argentinians and Latin Americans, I know that ensuring accountability for atrocity crimes represents values you cherish as a people who know firsthand what such devastating crimes can mean for the social fabric of society, for its harmony, its stability, and its well-being. The creation of a permanent international criminal court attempts to respond to the maxim of never again through concrete enforcement of the law of international criminal justice. And its origins lies in the unprecedented efforts of the Nuremberg and Tokyo military tribunals, where, for the first time, individuals, irrespective of rank or status, stood trial and were convicted for their roles in the egregious and systematic crimes committed during Second World War in particular. The atrocities witnessed during that war, including the horrors of the Holocaust, shocked humanity's conscience to make progress towards the creation of a permanent international criminal court with the aspiration of ensuring those who commit these serious crimes, no matter how powerful, are held to account. While laudable efforts to investigate and prosecute atrocity crimes at the national level were undertaken, the trial of the juntas in Argentina in the 80s is one example. Efforts to establish a permanent international mechanism to deal with atrocity crimes essentially froze during the bipolar Cold War. And the world had to continue to witness unspeakable crimes, including those committed in the former Yugoslavia and in Rwanda in the 90s, until it was ready to accept the need for a permanent court to try the world's most heinous and destabilizing crimes. As such, in Rome in 1998, the idea behind this aspiration was given effect with the creation of the world's first permanent international criminal court, complementary to national jurisdictions, with jurisdiction over genocide, crimes against humanity, war crimes, and since 2018, the crime of aggression. And the ICC was built as part of a wider effort to establish a rule-based order that aims to create a culture of accountability for atrocity crimes, contribute to their prevention, and therewith save future generations from the scourge of destructive power rivalry, perpetual conflicts, and mass atrocities. However, as I deliver these remarks today before you, I observe with concern that in this new century, we increasingly find ourselves confronted with threats to multilateralism and the post-World War II rule-based global order, where the sanctity of sovereignty is misappropriated in the service of exceptionalism and a rejection of international law and the rule of law. And that system, as we know it, is increasingly being challenged by potent forces. The setbacks we are currently witnessing are, however, not inevitable, and there are many countercurrents. Dear students, the court was not established in a vacuum, and nor does it today operate in a vacuum. It is often said that if someone would have the idea to create a court today, in the current state of the world in disarray, they would never succeed. But be that as it may, I posit that the creation of the court must be one of humanity's proudest moments. The ICC is a central pillar of a rule-based international system rooted in the respect for international law and the fight against impunity for the world's gravest crimes of concern to the international community. In 1998, over 120 states across the world signed the Rome Statute at the origin of the International Criminal Court, including, in no small measure, and thanks to the devoted involvement of many Latin American countries whose memories of atrocity crimes were still very fresh. In 2002, with 60 ratifications, a quarter of which were from Latin America, the treaty came into force, and the world, having created an independent judicial institution complementary to national jurisdiction with the mandate to investigate and prosecute the most serious crimes when national jurisdictions were unable or unwilling to do so. And with the creation of the International Criminal Court, an important normative, but also structural and system-based message was sent. The first, that the commission of mass atrocities as merely politics by other means will no longer receive a pass, and that perpetrators, irrespective of rank or official status, must answer for their crimes. Sent another message that an international criminal justice system is crucial to a rule-based global order. Its institutional manifestation in the form of the ICC is now a reality and an important part and parcel of the global order. Today, the court benefits from the membership of 123 states and has possibly greater reach due to the court's jurisdictional competence. Victims and affected communities are at the center of the international criminal justice system thus created. Indeed, there are many ways the court's raison d'etre. They are in many ways the court's raison d'etre and have a crucial role in the ICC proceedings. And this is exemplified also through the crucial mandate and work of the Trust Fund for Victims, which as a separate body from the court has as main mission to implement court-ordered reparations and to provide physical, psychological, and material support to victims and their families. Against this backdrop, with victims of atrocity crimes as its main drivers, since the start of its operations in 2003 under my predecessor, the first prosecutor, an Argentinian national, Luis Moreno Ocampo, the Office of the Prosecutor has endeavored to implement its crucial mandate to investigate and prosecute Rome Statute crimes with full independence and impartiality without fear or favor. To recall, the court has jurisdiction over crimes committed after 1st of July 2002 and has as potential operating theater in the territory of 123 states parties that have joined the court and beyond, given the powers of the UN Security Council to refer situations to the court, as well as the court's extraterritorial reach to also consider the conduct of nationals of states parties. Ladies and gentlemen, when I became prosecutor in 2012, the court has been functioning for nearly a decade. At the time, I felt it was important to engage in critical reflection on past performance and seek ways to improve the office and therewith the court. I undertook several changes, including a drastically different prosecutorial strategy with a major shift on how to investigate and build our cases. We also enhanced our quality control mechanisms, streamlined our procedures, and improved transparency. Under my leadership, the office has achieved a number of important litigation successes and landmark decisions, such as the ruling delivered in the Myanmar-Bangladesh situation, confirming the court's jurisdiction over the alleged deportation of Rohingya people. An investigation is now open in that situation. Also, the appellate ruling on head of state immunity in the al-Bashir case in the Darfur, Sudan situation, confirming that no one is above the law. We have also secured important convictions that do not only contribute to delivering justice to victims of mass atrocities, but also to the development of international criminal law jurisprudence. For example, in the Ntaganda case, emanating from our investigations in the Democratic Republic of Congo, my office secured the conviction of the accused on all counts, including for the first time in the court's history, the crime of sexual slavery, as well as the crime of rape against women and men. And through this case, we have contributed to emerging jurisprudence by extending the protection under international humanitarian law to also cover crimes committed by an armed group against members of their own group. In the Al-Mahdi case, which following our investigations in the situation in Mali, we sent a clear message that in the intentional attacks against historic monuments and buildings dedicated to religion is a serious crime under international law. In fact, just last week, And despite some pandemic-related restrictions, I was able to travel to Mali as part of a reparations ceremony to be close to the victims and the affected communities of such crimes during such important moment. And earlier this year, my office secured the conviction of Dominic Ongwen in relation to the Uganda situation on 61 counts of war crimes and crimes against humanity, which included important convictions on the basis of sexual and gender-based crimes and crimes against children, including for the first time, the crimes of forced marriage and forced pregnancy. As we speak, the office is busy with ongoing preliminary examinations. This is in the process to determine, in accordance with the strict legal criteria of the Rome Statute, if investigation should be initiated in multiple situations across the globe, including in Colombia, Venezuela, and Bolivia. And these criteria take into account the court's complementary nature, meaning that it will defer to domestic proceedings where possible. We are in parallel conducting active investigations, meaning we are collecting evidence in order to establish persons most responsible for the commission of crimes alleged in 9 situations, including in Mali, Bangladesh, Myanmar, the Central African Republic, Libya, Darfur, which is the Sudan situation, and Georgia. In Afghanistan, we are currently carefully assessing the documentation received from the government of Afghanistan in support of its request to the office to defer its national investigations, and this process is ongoing. With respect to the situation in Palestine, the judges of the pretrial chamber, having rendered a ruling by majority, clarifying the scope of the court's territorial jurisdiction following my office's requests, last month, I confirmed the initiation of an investigation. And I wish to emphasize here that my office conducts its activities consistently with utmost professionalism, independence, and impartiality, guided solely by its legal mandate as stipulated in the Rome Statute, and the information and evidence that emerges from its preliminary examinations and investigation activities. For me, this is critical to the credibility and longevity of an institution as important as the ICC, not least given the political environment in which our cases operate. There is increasing evidence based on the growing body of empirical research and criminal justice literature to believe that ICC decisions, in particular the prospects of convictions, are likely to contribute to changes in the calculus and behavior of would-be perpetrators. More generally, one can submit that based on studies and practice, that the ICC's jurisdiction and its legal framework, its work, and its engagement and symbiotic relationship with domestic authorities and other actors contribute to ensuring a greater awareness of and readiness to ensure adequate accountability responses and standards for human rights protection. So the impact of the court thus goes well beyond its actions in the courtroom or in the cases in its dockets. The decisions tangibly demonstrate also the unique contribution my office can make in the fight against impunity for those crimes that are typically underreported or insufficiently addressed at the domestic level, such as sexual and gender-based crimes, crimes against or affecting children. And I wish here to applaud the commendable efforts of Argentina, which I understand has developed important jurisprudence in this critical area, some of which refers to the Rome Statute. And this sets an excellent example of how important it is that both national and international mechanisms complement each other and strive to investigate and prosecute atrocity crimes. We have elevated sexual and gender-based crimes, crimes against or affecting children to key priorities under the office's strategic plans, and we've adopted comprehensive policy papers to highlight the importance of addressing these crimes, to elaborate on the applicable legal framework and take a systematic approach to the prosecution of these crimes, and to provide a reference to the extent that our work and best practices can be helpful to efforts at the national level. Indeed, a draft of a third policy on the protection of cultural heritage within the Rome Statute framework has just been published for comments, and we look forward to receiving input from relevant stakeholders for the office's careful consideration. To give full effect to the court's prosecutorial powers, its independent mandate, and the Rome Statute legal framework, that is, for the court to function effectively as intended and designed by its drafters, it needs to have the support and cooperation from its states parties and other stakeholders, including United Nations entities and regional organizations such as the European Union or the Organization of the American States. My office, in the exercise of its core functions, that is preliminary examinations, investigations, and prosecutions, engages with a myriad of actors, including early responders. In particular, during the initial stage of the engagement in a situation to ensure the preservation of evidence and the domestic authorities throughout the whole process. My office's engagement with its stakeholders is rich and diverse. Support is required not only to ensure the requisite level of assistance to our operations, but also to enhance diplomatic and political support for our work, to protect the court's integrity and independence, and to improve the general understanding of the court's mandate. We are proud of the relationships of trust and mutual respect that we have fostered during my tenure. This is important also because we are at a juncture where, as I mentioned, concepts and manifestations of multilateralism and the rule-based global order are increasingly challenged and at times even rejected. My office and I personally have our own share of experiences in this regard. And an example was the executive order, which was issued last year by the previous US administration, under which it notably imposed economic sanctions on me and a senior staff member of my office. So this past Friday, the Biden administration revoked the executive order ending the sanctions and other restrictive measures, and we welcome that decision. Like the court, many states parties also welcomed the decision. But during these testing times, the court and its states parties, including many Latin American countries, demonstrated resilience, including by publicly denouncing such measures and tactics. This has been an important reminder to all states parties as custodians of the Rome Statute on the need to develop a mechanism which will systematically protect the court and its integrity on the face of any threats or attacks so that it can continue to dutifully fulfill its important mandate in situations requiring its attention. By the very nature of its work, the court is bound to generate a degree of pushback or a sense of unease. We have seen this in various situations where the court operates, but we must dispel deliberate misrepresentations of the court's work and mandate. We must continue to stand firm in our resolve and speak with one voice that the commission of mass atrocities as merely politics by other means will no longer receive a pass, and that perpetrators, irrespective of rank or official status, must answer for their crimes. We must continue to work for the victims of atrocity crimes who look at the court as a last beacon of hope. An important role here is also for the president of the Assembly of States Parties. Since February this year, this role is held by Argentinian national and a former Rome delegate and ICC president, President Silvia Fernandez de Gurmandi. Under her leadership, states parties can play a key role in defending the court that they have created. What is right and the suffering and plight of victims of atrocity crimes must not be sacrificed at the altar of political expediency. Today, what is required is more justice and accountability, not less. I only have a few months, I think barely 2 months, left to serve as prosecutor of the ICC. During my term, I have done everything in my power to honor the responsibility that has been bestowed upon me by states parties and the trust conferred to me by victims and affected communities by implementing the crucial prosecutorial mandate to the best of my ability, always in accordance with legal confines of the Rome Statute with integrity, independence, and impartiality. Dear friends, ultimately, international criminal justice with the ICC at its core serves humanity as a whole. Before I end this lecture, I wish to highlight the role played by academia in supporting and strengthening the International Criminal Justice Project. The academic study of international accountability for atrocity crimes is indeed necessary to ensure its success. I encourage young students to equip themselves with the knowledge and the conviction that taking bold and meaningful action through the force of the law is key to protecting citizenry from the scourge of war and mass atrocities. I encourage you to follow closely the ICC and other institutions working to advance the rule of law and to support them if you care about a more just world, for they are too important to falter. And I encourage you to become ambassadors for the International Criminal Justice Project with the ICC as its central pillar. Each of you in his or her own way, as you become the next generation of lawyers, political advisors, advocates, analysts, researchers, diplomats, consultants, and beyond. The future awaits to embrace you, your ideas and achievements. At a time when negative forces aim to divide our society, I have complete faith in the new generation, in the talented young students like you in this room, who will carry the torch of enlightenment, tolerance, and progress as you enter a new promising chapter of your lives. Let us all carry forward our work with this devotion, in the hope that it can be replicated for the sake of victims of atrocity crimes the world over, and for the sake of future generations. A permanent international criminal court is important more than ever because history has taught us in Latin America and beyond that accountability is key for durable peace and progress. As such, a permanent international criminal court deserves our unflinching support, not for its own sake, but for the sake of humanity. I thank you all for your attention, and I look forward to your questions and comments. Muchas gracias.
Thank you so much, Prosecutor Bensouda, for a fantastic talk, and particularly for your words on the importance of the International Criminal Justice Project in these troubling times, and the relevance of bringing newer generations of lawyers and academics into the debate. We have a number of questions. Please, if you have more questions, send them through the chat function. The first question, I think, is something we've all been deeply concerned about. And Martin Jurek asks, how have the sanctions of the US affected your work and the work of your office, and whether you envision a new era in the relationship between the International Criminal Court and the United States?
Should we do question after question, or we take a block?
I think they take on very different aspects. So perhaps we can do question after question, and if I can join some of them in a block, I will do that for you.
Very well, very well. Thank you very much, and thank you for patiently listening to me. Yes, indeed, this I would say is perhaps the hot topic of the day. The sanctions, as you all know, that since last year, these sanctions were imposed on myself and another staff of the office following the executive order in June. It has indeed impacted the way we work. First and foremost, since the sanctions were imposed, We of course, we sought legal advice on those who are more versed in this in the area to advise both the court and the office. And we discovered that, for instance, I, as a designated individual, could not directly task, let's say, American nationals. And there are American nationals in the office who are also occupying responsible positions. So I could not task them, even though as a prosecutor, I have leadership of the office. So we had to rearrange the office in such a way that those of the, let's say, senior trial lawyers who are working on cases will be reporting to my deputy. Because, I mean, if the sanctions were to be invoked, they would have affected them immediately. So we did this. We also worked very closely with those situations that are really the ones that have caused the sanctions to be imposed, such as Argentina and Palestine case. We had to discuss with them on how we will work henceforth, because we also did not want to impose them. We had to talk to my staff so that they understand what was happening, and at the same time to also know that things will have to be done differently. The office, we had to create Chinese walls, we had to create reporting lines, all those had to happen. And at the same time also, apart from that, the administration aspect of it, there was also the issue of the travel bans, visa restrictions. I was no longer able to go to the UN Security Council. As you know, I do report on the cases of Libya as well as Sudan, which was a referral from the UN Security Council. I could no longer go there. Indeed, it even affected other invitations that I would normally receive as prosecutor of the ICC to attend certain functions in the US. This happened at the very beginning, even before the executive order. With respect to finances as well, having worked for the UN ICTR before, normally you would all open accounts with the UNFCU, which is based in New York, and those accounts were blocked. I could no longer access them. Even there are accounts here in the Netherlands, which they informed us that we could not access them because they were the intermediary bank, or they are either American-based bank or their intermediary bank that was American. So many other inconveniences, both personal and at the professional level, were caused. And but I must say that I would take the opportunity to also appreciate the way in which the court has reacted. The registrar has and his team has done very well in trying to facilitate things for us, such as transfers, and my own team within my office has also done very well in trying to get the legal advice that was needed, and to also see how we can work more effectively, not to expose other staff, and also not to force certain other sanctions on myself or other people. So this was really quite inconvenient. And also maybe the most inconvenient was the fact that if you look at these sanctions, these are sanctions that are reserved for terrorists, that are reserved for violators of human rights. These are the kind of sanctions for them, or maybe corrupt persons, but definitely not for those who are working to advance the rule of law, who are working to advance justice. So just to be part of that list is something that really should not have happened. But as I said, we welcome the fact that it has been lifted now. The sanctions have been lifted, and we are working to have what we call a reset of the relationship between the ICC and the US administration.
Yeah, I think that's a very important and a very important outcome of a very unfortunate situation. So I have two questions which also relate to another hot topic, I think, particularly in the region. Augusto Ruiz de los Llanos asked whether the serious irresponsibility with which some presidents have handled the COVID-19 situation could not be the typecast within the category of crimes against humanity. And Aline Martini, she asked Prosecutor Bensouda, I would like to congratulate you for your excellent work during your mandate. And her question is whether the ICC has received any kind of presentation against Brazilian President Bolsonaro concerning the COVID-19 mismanagement. So pandemics and the work of the court are the topic of this next couple of questions.
All right. With respect to the pandemic and the different way in which it is being handled by, unfortunately, some leaders, which I think could have been done better. Okay, I would say that currently my office is, because we've got a lot of communication on that, and we're carefully analyzing what it means. Because as you know, the elements of crimes against humanity is directly attacking, civilians and systematic, widespread and systematic attack on civilians with intention to do so. So we must see that the elements are present in any situation. This is what we do before we come to any conclusion that this should qualify as crimes against humanity or war crimes or genocide for that matter. And I would say that my office has really not arrived at that conclusion yet. Certainly, there is much more information needed, and we really have to see that deliberately this pandemic is being used by leaders to attack its citizens. I don't know, but we have to find those elements first before we can come to any conclusion that this was the intention to wipe away your citizenry by using the pandemic. We need to find that. Again, you mentioned about communication against Bolsonaro. I can say that we have what is called Article 15 communications. And this Article 15 communications can come from anywhere. It can come from nationals of a state. It can come from NGOs. It can come civil society generally. And it can just come to inform and give us information about what is happening that the court could potentially have jurisdiction on. And I will say that, in fact, there are in some instances which, first let me say that those communications we usually keep confidential. We do not reveal it unless those who communicate to us make it public. Then we confirm it. And I do know that in some situations, I believe that there are some communications that have already been made public that was sent to our office, which I will confirm. And as you said, this has to do with the situation in Brazil, and also the communication that was made public recently in the Brazilian papers about the president of Brazil, Bolsonaro.
Thank you, Prosecutor. I have a quite different question from Justina Uriburu. She again thanks you very much for a powerful presentation. And she wants to ask on an issue that she's sure you will have addressed on several occasions in the past. It is often said, she says, that the International Criminal Court has been facing a deep legitimacy crisis. One of the reasons is the so-called African bias, or maybe what today could be more accurately described as a focus on prosecutions in the third world. What are your views on this legitimacy crisis, and what do you think that the court can do to counter it? And how can the court be more accountable to its own constituents?
I think indeed you're right. This is a question that I have received, I think, throughout my term as prosecutor, but even as deputy prosecutor, I have received this question, and the court has suffered from this accusation of Africa bias, of concentrating only on Africa and not other continents. And despite the fact that people never used to, or people did not always take into account that we are not in Africa or prosecuting cases in Africa out of will, because this is our desire to do so. It was because of the call of Africa to the ICC to come in and intervene. And if you look at all the situations, I can repeat them here, but if you look at all the situations, almost all of them were a referral from African states calling on the ICC to step in and investigate. So I do not think that it is justified to say that after those referrals, then ICC is concentrating on Africa. I think far from it. But again, today, if you look at the case docket of the ICC, I believe that we have been completely vindicated. It's our cases are no longer only focused in Africa. We are outside of Africa. We're doing several preliminary examinations that are not in Africa, investigations that are not in Africa. And also, even this accusation that third world countries, I think that also we've been completely vindicated as a result of that. If you just look at the case docket that we have, I took chance to mention most of them or all of them during my presentation. We are in a different status now. We are in a different state. And I believe that is what those who are commentators on the court and those who are looking for the court to do well should avert their minds to. That the court is no longer in that position. The court has moved on. The court is showing that it was a court set up to investigate these crimes wherever they may occur, and we have jurisdiction. So we also need to bear that in mind. Wherever they may occur and we have jurisdiction, we will not shy away. The court will not shy away. My office will not shy away from taking on those cases, as long as our jurisdiction is satisfied, and as long as these are crimes that fall under ICC's jurisdiction. So I do not think that it's even fair. It has never been to say that ICC is focusing on Africa, because I think that Africa had taken leadership in international criminal justice by referring situations to the ICC. I believe so. And throughout, I can tell you, throughout the investigations that we are carrying out in Africa, we receive almost 99% support from individual African states. We have had our political differences with the African Union, of course, because certain heads of states chose to use the African Union, a political body, to push the ICC back and to make the Union to come up with resolutions to say that ICC will not be cooperated with. But you have seen that things have changed in even some of those situations, like Sudan, for instance. Today, I mean, we are able to go to Sudan. My investigations are going. I have been able to go there. We also have a reset, more or less, with Sudan for the first time. We've signed a memorandum of understanding to be, as someone has surrendered to the court in the Sudan case. So it's very different from what it was. And this criticism of ICC focusing on Africa is no longer valid.
Thanks a lot. I have a follow-up question, which is the other side of the coin of your argument, which again has to do with prosecutorial strategy and how you've defined it and in your presentation and in your recent response. So, what stock do you take regarding the expansion of the reach of the ICC? Today, the Office of the Prosecutor investigates situations where Americans, Russians, and Israeli nationals could be prosecuted. How has that changed the political capital the ICC has to pursue a justice agenda?
Indeed, as I said, we are only following the dictates of the law, the Rome Statute. Where do we have jurisdiction? Why do we go there? we have to go there, go anywhere in full transparency, and always be able to justify that it is purely following the dictates of the Rome Statute that we are there. So we're in different places that you've mentioned. The fact that in Afghanistan, it's the situation. Afghanistan is a state party to the Rome Statute. And we were in preliminary examination with Afghanistan for quite some time before this step was taken to investigate, but also to look at the conduct of others that commit, allegedly commit crimes, atrocity crimes on the territory of Afghanistan. And this is why we have this request to also investigate the conduct of American personnel in Afghanistan. In Palestine, I believe I have already explained, especially in my recent statement with respect to the referral that we received from Palestine, and also the fact that they had accepted ICC's jurisdiction. The issue with Palestine has never been about determining statehood of Palestine. I've been very, very clear from the beginning. It was always about having jurisdiction and to be able to investigate Palestine because it is considered a state party to the Rome Statute. This is so. Again, I'm explaining these situations just so it is seen that we are not just frivolously going to investigate people. It's not frivolous. It is fully and always justified by what is provided for under the Rome Statute, and that is what we follow. If you look at the case of Palestine, Israel, for instance, we've been very, very careful by using Article 19.3 to go to the chamber and to tell the chamber that this is what we have found over the 5 years in which we were looking at this situation. But we would want the chamber to determine the scope of that jurisdiction. But that we were clear that ICC has jurisdiction based on the state party membership of Palestine, and that the crimes occurred on the territory of Palestine. So this is where we are. The judges have agreed with us by majority that yes, the Office of the Prosecutor has taken the correct analysis and view of the situation, and they granted that clarity to us. And I have been able to announce officially that the investigations have opened. As I said, again, this is all in accordance with the Rome Statute. I'm not overreaching. My office is not overreaching. We are not working because of political considerations. We are merely sticking to what the Rome Statute says, and that's what we are trying to apply. And indeed, the case docket, as you rightly said, of the office has expanded, and of the court has expanded. I would even say exponentially. Of course, it comes with other challenges, and those are the challenges of resources and so on, which we will have to manage. But I am sure the incoming OTP administration prosecutor will really have to also look into how to manage and adjust to the new reality that we face.
Thank you. I have another question, which is very close to the Latin American sort of sensibility on international criminal justice and some of the issues that are often discussed here in the press and in politics, which is by Tairi Moya asks, which are your impressions in regard to the link between corruption and international crimes? Do you think that the court can evaluate how corruption can have an impact on the commission of international crimes in any of the situation or cases?
I mean, this is a discussion that comes quite often, but it is one that I believe it is for the states parties to have a serious discussion on this, because as you know, with the court, we get the Rome Statute, which has already been negotiated, and then we of course apply what the statute says. But I think it's a discussion that needs to be taken up at that level, because we know that through corruption, unfortunately, a lots of lives get lost. We know that, because sometimes resources that are meant for people to be able to do other things, greater things, advance their economy, develop, sometimes as a result of corruption, this cannot happen. And whether that link can be taken to the extent of saying that it is as a result of these corrupt acts that it translates into an attack, a direct attack on the civilian population with intention in a widespread and systematic way, is that it's a discussion. What I'm trying to say is that it's a discussion. And I do know that for several years now, there have been groups of individuals who have been trying to advance that discussion, and to see whether this is a matter that ICC should be looking at. But unless we have that green light, if I may put it that way, in the statute, within the Rome Statute, we will not be able to directly make that link and call it as a crime against humanity. But I think it's a discussion that should be had. If it is not going to be, if it cannot be justified that it should be there, then perhaps to stop the discussion. But I believe it should be had, because we have had, it's not only in your part of the world that we have this, but also in my part of the world, and I believe in several parts of the world, this is happening, and this is impacting people in a very, very bad way.
Thank you very much. I think we have 5 more minutes, so we are extremely grateful for your time. And I have one question which sort of follows up from the visit we had last year by Elizabeth Odio Benito. She's the president of the Inter-American Court of Human Rights, as you well know. And she discussed the obstacles and the challenges she had as a woman in international justice. And the question is, what has been your experience as a woman in international criminal justice in particular, and what obstacles and challenges you have had to face for that?
Well, you know, I see the challenges not just as a woman, which I am very happy to be, but also as the prosecutor of the International Criminal Court. You really face many different challenges, and I could go on and on. Resource issue, politicization, accusations, the fact that every kind of step or decision you take will be misinterpreted, or will be said that it's taken as a result of this or that, never because of the law. And also the pushback that you continuously receive as prosecutor of the ICC in carrying your work forward, the lack of cooperation, or the pretense at cooperation when really it's not happening. I have faced all of that in this. But as a woman, I think it has been quite an interesting ride. And I always say that I do not regret that I have taken this position on, and I have always tried to do my best, to give it my best with determination and also with sense of purpose. I have never, in most of the time, my gender is the last thing I think about, because I do believe that contrary to what many still believe, unfortunately, that a woman's role should be this or that, but never as high as, I don't believe in that. I think that we have, through several dynamic women, including Odio Benito, we have demonstrated that this is not just true, and that women can be whatever they want to be, as long as they are very well equipped for that. And even though the glass ceilings are constructed, are built for you to stop there, I always say that those glass ceilings are meant to be shattered, and for the woman to always show have full and true potential and the contributions that they can make in any field, including in international criminal justice.
And you're a fantastic example of that. If I can ask you one last quick question regarding the issue of structural inequality and international criminal justice. So Francisco Quintana asks, the court has faced significant challenges and constraints to fulfill the very functions the states assigned it in the Rome Statute, namely to put an end to impunity for the perpetrators of international crimes. He says, one can only empathize with the work of the Office of the Prosecutor towards this goal in this challenging context. However, at the same time, the ICC might be dealing with a different problem. The fact that it seems to no longer embody the sort of progressive utopia so cherished in the late 1990s. So today, many progressives are more concerned with material inequality between and within countries and institutional racism than impunity. So the question is, can the Office of the Prosecutor and/or the International Criminal Court do something to appeal to those internationalists more concerned with structural injustices than accountability?
You see, we always have to remember that the International Criminal Court was set for a purpose, which is very, very clear. And this purpose is to ensure that war crimes, crimes against humanity, genocide, and now the crime of aggression, these very serious crimes that we say shock the conscience of humanity, are investigated and they are prosecuted. And that we continuously demonstrate that no one is above the law and no one is below the law, and that the victims of these crimes have to see that justice is done. This basically, of course, we are complementary to national jurisdictions and all that, but this is basically what the role of the ICC is for the moment. And this is what the OTP has been trying to achieve, will continue to try to achieve. One thing that you have to recall is that by the very nature of what we do, we will continuously, this court, long after I'm gone, this court will continue and the office will continue to receive pushback because of what we do, because we try to investigate and prosecute and bring powerful people to justice. There will be pushback. There will continue to be pushback. And I came into this role myself with my eyes wide open, knowing that it's not going to be a walk in the park, knowing that it's going to have its challenges, it's going to have difficulties. But what are the ways? How can we find, how can we resolve those challenges? How can we confront those challenges? One of them you have mentioned is this issue of equality. I think that what we have tried to do, what I have tried to do here, is also to work on gender issues, for instance, and to give women equal opportunities. We have come a long way. We're still not there. As a court, we have worked on that. We continue to work on that. In fact, I am one of the gender champions that has been chosen just recently. But my idea is to say that if you also give women equal opportunities to stand next to men, soldier to soldier, and we will be able to also give a positive contribution to that. So the structure that you build to carry out these investigations and the prosecution should also be a fair and a structure that takes into account the issue of equality between the sexes. This is critically important, and no woman should feel that they are left behind because of their gender. Just like I say with respect to crimes, I don't think that any woman or any girl deserves to live in fear of violence or in violence. Even in fear of violence, no girl or no woman deserves to live that way. So when you're guided by these these principles within the own structure, your own structure that you build, reaching out to different structures as well, I think in the end, we can, in a coordinated fashion, be able to address, at least if not totally, but adequately, we will be able to address these issues of inequality.
Thank you so much, Prosecutor Bensouda. I'm afraid that unfortunately our time is up. We are so grateful for your time. We are grateful for an outstanding presentation and for the openness and generosity with which you've answered the great questions from the audience. But I also want to particularly thank you for your outstanding, fantastic work in fulfilling a function that is key for the whole world and for victims all over the world. It's been an honor to have you at Ditellianas today. Many thanks.
Thank you. Thank you very much for all your support, and thanks for having me.